Second slide. So basically, we want to talk about what administration means. We'll talk about the concept, the benefit, the purpose of planning, why it is important to make plans while you are still alive. Of course, I'm sure a lot of us, particularly when you're in your middle age, you have acquired a few things, including your cars, shares, investments, land, houses, and all of that. And one very key question is, how do I protect this thing? How do I ensure that my lifetime sweat and engagement and exertions does not go to wrong hands? And because we live in a very interesting society where people often fight over properties. I mean, you have a lot of disputes among family members. People who have once upon a time were cordial, were united. All of a sudden, someone dies in the family and everybody begins to fight over who gets the land, who gets this one, who gets that one. Now, my business this afternoon is to take us through, in a very summary form, how do you make plans for those things, those emergencies? And then is it okay to make plans for how your properties or your assets are managed while you are still alive? What are some of those questions? Or do you have, a person has to wait until he dies before you begin to talk about your assets? Now, and of course, we talk about what do you do in place of incapacitation? I mean, we've heard a lot of talks about health and healthy living and all of that, but some things are far beyond us. Like the doctor that Dr. Teofilo referred to, he never planned to have a blind eye. That's a form of incapacitation. And some people have dementia. When someone has dementia and the person has 2 billion naira in his account, what happens? How does the person protect? How do you ensure that that 2 billion naira is not stolen by account officer? How do you ensure that that 2 billion is not stolen or pilfered away by people that ordinarily should not benefit while the family is left to suffer? We have had a lot of experiences in this profession where someone dies and he had a lot of means. And because of lack of proper, adequate planning for his succession, he dies, and then the children are out of school. The children that were the kind of wealth that their father left for them could actually take them to as far as Harvard. And yet, they became so indigent, so impoverished, and they begin to suffer. Meanwhile, they have billions lying down in the name of their father somewhere in a bank, and they are totally unaware. These are some of the issues that we have to deal with. And then we have to talk about the components of estate planning. And then there's also this conversation around next of kin. Can a next of kin inherit your assets? The fact that your father is a director in a public institution, a parastatal, and he names you as his next of kin, does that automatically entitle you to his gratuity after he dies? Or the fact that somebody names his side chick, and it happens a lot in civil service. I just dealt with one not too long ago, where, a director, he was a full director. He had all the assets, had houses, had lands everywhere. But the side chick got more than the wife and the children, because everything he did, the person he mentioned as his next of kin was the side chick. And the side chick decided to take all those assets on the basis that, after all, she's the next of kin. The question is, the fact that she was named as next of kin, not the documentation, does that entitle her automatically to the man's assets? So I can see some of us are shaking our heads. And you are shaking your heads because you are saying, God forbid. How can a woman that has been a wife of someone's youth, who has suffered with the person for 50 years, all of a sudden is thrown into the streets? All of a sudden, they become so impoverished, they can't even afford to pay rent. Meanwhile, Oga director and the side chick is swimming away in the money. She's buying bone straights of 600K. 2 million, 3 million. I was telling my colleague there that some women, what you wear on your head is actually a plot of land. Yes. That's how we look at things as men. So what you put on your head in the name of wig or your wigs is actually a plot of land. We are thinking properties. So next time, please look at any lady sitting next to you. Say, I hope you don't have a plot of land on your head. They are not here. All right. So these are some of the common issues that we have to deal with. So let's quickly go into the introduction. Basically, estate planning or estate administration are important legal processes that ensure that a person's assets are properly managed during their lifetime and well distributed also after their death. So estate planning is not just for purpose of when the person is dead, it's also for the purpose when you are alive. What do you want to do? You have acquired 10 houses, what do you want to do about it? And you have 4 children. In your lifetime, you can actually transfer those assets to those children the way you want to have it. So that if there's any objection from any of them, you can deal with those objections in your lifetime. So that they will not have to resort to disputes when you are no more. We have a lot of prominent families, even lawyers, who are in court today. The MK Abiola family, we have the FRA Williams, the doyen of the legal judiciary in Nigeria. They are in court today fighting very, very contentiously over their father's assets. 2 of them are, one of them is a senior advocate of Nigeria, the other one is and they have over 10 cases in court over inheritance. Now, of course, we also know that there's a correlation between succession law in Nigeria and customs. Our customs, a lot of time, dictate who gets what. Like in Yoruba land, you have the culture they call the Idigi. Idigi simply means that the male child of the particular, for instance, if a man has 3 wives, the first male child for each of them is the one in whose customarily now the property will vest. He now decides out of his goodwill and at his discretion who he gives what out of what he has acquired. If he decides to be very selfish, he can keep everything. But if he wants to be generous, he can give to other people. That's culture. You also have a cultural practice in the East where, particularly in Inewi, where people, if the female child, if a man dies without a male child, all the female children in the family, they have no right to inherit their father. Those are cultural practices that are, and a lot of time the courts have had to step in to stop those kind of cultural practices because they are anti the Constitution. And we have the Supreme Court has struck down some of those cultural practices because they are contrary and repugnant to natural justice. How can somebody who has 4 children, and simply because they are daughters, they will not have anything on their father's property? Meanwhile, the father has houses and lands and everywhere. Now, I want us to know that estate planning is actually very scriptural. In Proverbs 13, verse 22, the Bible says, a good man leaves an inheritance for his children. So in estate planning, you are not just thinking about your children, you're also thinking about your grandchildren, your children. And of course, estate planning also can involve into, you can decide to set up a business for which you want to live for generations. If you read Joshua chapter 13 to 20, Joshua 13 to 21, you see where Joshua, after they have conquered the land, Joshua had to put down the distribution of Canaan, land of Canaan, the family of Judah. This is your portion. From this river to this river, that's inheritance. The family of Simeon, this is your own from this place to this boundary. The water that separates Euphrates to this place, that's the boundary between you and this tribe. And that was why, as a result of that, there was peace in the land. The only people that God gave instruction for them not to own land are the Levites. Because God said their portion would be from what? From the temple. That was clear instruction from God. And they followed that, and there was peace on the land. Now, common causes of family disputes in Nigeria has been known to be on inheritance and family planning. Next slide. Common causes of family disputes. A lot of disputes arises when someone dies where there is no will. Somebody dies without a will. Conflict also arises between customary law and the English laws. And let me say it here that the principle and the concept of writing will and testamentary disposition is an English law concept. Meaning that, Nigeria, we are under the common law jurisdiction. So we inherited the English law because we were colonized by the English. So we inherited, part of the law we inherited them is the wills law. the law that governs the writing of wills and all of that. So will is kind of alien to our culture. But when we received the English law, we adopted it. So the English law has given us a better opportunity to make arrangement for estates while we are alive or even after the person is gone. If someone dies without a will, what happens? What happens? These are some of the questions. Does it mean that anybody can just wake up and send the wife out of the house, send the children out of the house, and take over the land? I've heard gory stories of people where someone just dies and the brother steps into the house and they're asking for car keys. Where's the bank account? Where is this one? Where is that one? And you mean a woman is in sorrow, she's mourning, and all I have about is cars, houses. You don't even give her the period to mourn. And the law will always step in to intervene in such situations because those practices are repugnant to natural justice. There are multiple marriages. Because we also live in Africa, one of the things that cause family disputes, prolonged family disputes, is extended family. This practice of, polygamy, where a man marries several wives. And I have a friend, one of my, it's a very funny story, really. He's from Bayelsa. He had always believed that I was the firstborn of his late father. The father died some 2 years ago. And at the funeral ceremony, they were already, every arrangement had been made. So it was time for lying in states. And the father was there. And the priest called him and said, step forward. They are from the Anglican faith. He stepped forward. You know what they say, earth to earth. So it's time to take the earth. It was as he was about to perform that ceremony, somebody showed up. And the person that showed up, you know what the outside people call, meeting grima? The guy when the guy showed up, it was a replica of his late father. In fact, he said, according to him, that he was scared because he was thinking that perhaps maybe the father resurrected. So, apparently, father had a first son outside, totally unknown to the entire family, including my friend. My friend was the firstborn of 3 of them in the family. So all along, they never got any idea. It was not written, it was not said to anybody, and the man took that secret to the grave. It was at the funeral ceremony when the man was about to be interned that the firstborn showed up. In fact, my friend said that as he saw the firstborn, as he saw the man, and the man took over, he just took over and said, my friend, move. When they looked at him, he said the resemblance was so uncanny that you don't need any DNA tests. There was in fact, all the things that he thought he had, the guy had them in double, as far as resembling the father was concerned. Those are surprises that could come up, that could spring up. Now, imagine if that man had done a will and put that person's name there. My friend and all his siblings and their mother would just be left left helpless, as it were. Now, unclear property ownership. Sometimes some men hide their assets. And these are some of the problems. So, wives, you need to start to talk to your husbands. Husband, we need to open up to our wives. No secrets. Don't hide anything. This is your wife. You have lived your life with the person, and you are hiding secrets. You have some properties that you are not naming. The day, God forbid, the day you die, those people, that property you are hiding, that's where it will just go. And people will just take it over. People that have not worked for it, people that don't deserve it. Mismanagement by executors and administrators. Sometimes somebody dies and there's a will. Please go to the next slide. Now, the concept and purpose of estate planning. Why are we talking about estate planning? I've opened up our minds to some of the problems and the challenges we have. So, will you say it's preferable to organize estates before God calls you home, or just leave everything scattered and then let things take care of itself? Which do you think is better? The one you take care of before in your lifetime. So that's always the preferred option. And that's why we often encourage that. If you are a man, you are working, once you are 50, go and do a will. If God helps you to live up to 50, that is. But we recommend usually that once you are 45 and you have acquired one or two, whatever it is, even if it's just one car, even if it's just one house or a land, do a will. And the thing is, you can always update your will by doing what we call a codicil. You can always execute a codicil to amend what you... So as you acquire more, you amend it to accommodate more. It's possible that when you did your first will, you had just 2 children. Now God has expanded your coast. You now have 6. So you need to accommodate those other ones. So you do a codicil to accommodate the rest of them. It's possible that you had just 2 properties when you did the first will. When you acquire more property, the law gives you the allowance to call your lawyer back and say, you know what, I've added so. I bought shares there. I'm a part of this business. I'm a shareholder in this company. Please, I need to arrange this. And then a codicil will be done to take care of that. Now, estate planning essentially is about deciding what will happen to your money and other assets when you die. It's as simple as that. So if you don't take anything away, just take it away that estate plan is all about deciding in your lifetime what happened to your money and your assets when you die. Do you want it to be taken away by the birth of the heir? Or do you want some other person to take it? So let's go to the next slide. The purpose of estate planning. 1, smooth transfer of assets. Number 2, prevention of family disputes. 3, protection of dependents. Efficient management of assets. Avoidance of intestacy. Now, intestacy is essentially where, it's just a technical term that means that somebody dies without a will. When someone dies with a will, we said it dies testate. Testate from the word estate. Testate. That means he left a will at testamentary disposition. When somebody dies without a will, we said it dies intestate. What are the benefits? Please go to the benefit, the next slide. Benefits of estate planning. Number 1, family protection and harmony. I cannot overemphasize this. One of the surest ways to ensure that your family, there's harmony, there's peace, there's continuity in your family is to ensure that you plan all the assets the way you want it to be done in your absence. And that the best time to do that is while you are alive. 2, prevention of prolonged legal battle. I mentioned the FRA Williams family. They've been on that case now for almost 20 years, and there's no resolution in sight. And they will go to Supreme Court. Everybody that is prominent in legal profession has intervened. Yes, because the first son insisted that he was the firstborn and he was entitled to so. The father owns a lot of skyscrapers in Lagos. FRA Williams is one of the most celebrated, one of the earliest SAN that we have in Nigeria, and a very brilliant one at that. But he made a mistake. When he died, there was a will that was not quite okay. That will seemed to favor his other son, Florenshaw. And Ladi, who is the firstborn, is insisting that no, this is not good. So they went to court to challenge it. And of course, battles over fights, and then who get this, who get that. Some of them started coming and say, no, when my father was on a sick bed, he promised me that this skyscraper on Moloney Street was my own. How come is your name that is there? That's a dispute. That's a dispute. The Abiola family, MKO, that one too, they have their own. Fernandez, I don't know how many of us have heard of Fernandez. Chief Fernandez, he has his own. In fact, Fernandez, I got involved in Fernandez. It's just horrible. There are a lot of things that we cannot say here. Now, asset control and distribution. Incapacity planning. Now, another important part of estate planning is incapacity, where, if for health reasons, somebody has just gone to, doctor has told us that we should go for check at least once in a year. You have gone to consult Dr. Theophilus, and they've given you your health analysis for the year. And they've told you that they found something in your body that they suspect that you have only 3 more years to go. What happened? Or the ailment is such that it can be managed, but you will have what I'll call maybe intermittent amnesia. Today you remember, today you not remember. You know you have 2 plots of land in Lugbe, but you remember only 1. So how do you plan for such emergencies, such occurrences? The law has given us the latitude to make these plans for these things, for eventualities. And at times that somebody become incapacitated also by reason of not just health, but mobility. If you have assets in the UK or in the US, and an accident happened in Nigeria, and you have become amputated, and you can't travel, you have reduced mobility, or some other things, you can actually, there are arrangements that can be made for someone who is over there to manage those assets for you in the way you want them to be done. Business continuity. Some people we have a lot of high net individuals who have companies. Like Dangote, for instance. Dangote is a group, it's a conglomerate, has several subsidiaries. Now imagine, God forbid, the man passes on today, and there's no plan. Whether it's Alima, Fatima, or Zainab. No plan. What do you think will happen? Even if I have small shares, I will show up now. No, it's true. I have shares now, but my share is very significant. But that's a sense of ownership. All those directors that you think that are very loyal, all those Indian men working for you, do you think that they're loyal? All those Lebanese who are heading whatever, you think they are loyal? Their eyes are on those properties. The first one that will be on dispute is the refinery, because that's the biggest cow right now. Now, those are the kind of things, and then tax efficiency. This is another aspect of it where it also helps to manage your tax efficiency. That for strategic planning to allow to allow you to implement structures that minimize your tax exposure and inheritance. You know, under inheritance law, there are certain taxes that are fixed on assets when you are doing inheritance, when you are doing probate inheritance and all of that. So if you are able to devolve them before you die, then those taxes will not apply. Charitable giving also allows you to give to charity. There are some people that they have assets. There's one of my clients that we just read his will. He died in testate. He had a will, and the man was very specific. He made the arrangement for burial costs. He made the arrangement for the kind of tomb he wants to be buried, where he wants to be buried. He made the arrangement for cost of the burial, reception, everything was well catered for. Because he didn't want to stress the children and every other person, raising money, go fund me. So the man just made the arrangement for everything. And one of the other things he made the arrangement for, he said a particular percentage of his net worth should go to charity. And he mentioned those charity organizations that he wants to fund. So those are the kind of things we're talking about. Let's go to the next slide, please. Devolution of rights. Now, we have assets, we have properties. There are some ways that we can devolve property, that you can devolve or transfer title. And there are two broad categories. The first category is lifetime transfer. This is what we call intervivors. Intervivors means that in your lifetime. Intervivors simply means in your lifetime. Now, you can do your transfer in your lifetime by simply doing what we call, there's an instrument, it's a deed. We call it deed of gift. And a deed of gift, you can use the deed of gift to transfer property from a father to the wife, or from the wife to the son, or from the wife from the father or the mother to the daughter. And I hope you know that it's not just the man that is allowed under the law to do a will. A woman can also do a will. All human beings can do a will, as long as you have reached the legal age and you have acquired properties. So a woman can decide to give, maybe she buys let's say 5 plots of land in Asokoro. She has houses all over Abuja, and she has 3 daughters. In her lifetime, she does not need to transfer those. She doesn't need to wait until she dies before those properties are transferred to the children. In her lifetime, she can transfer it to them, just like you have in the case of a sale, when you sell. So under the lifetime transfers, we have gift intervivors, we have sale, a conveyance. That's where you buy from one person to another. You can approach the government, you can buy land directly from government, you can buy from another person, and all of that. So a sale simply means transfer of property ownership in exchange for money. So I have a plot of land I want to sell. You can sell. That's a form of transfer. There's another one we call lease. Lease are arrangement for a short time within the lifespan of that person. And when I say short time, technically a lease is from 3 years and above. So you can have a property. Let's say you have a property in Lagos. Now you are transferred to Abuja. And that property is such that maybe it's commercial. Let's say it's a warehouse. You can actually, if you don't want to lose ownership control, one of the ways you can do is to find a company that will lease that property, let's say for the next 20 years or the next 10 years, and you'll be earning money called rent. You'll be earning what we call rent on it for the next 10 years, right? And after 10 years, the ownership will revert back to you. So in a lease arrangement, you do not lose your ownership. You only give your right of possession to someone temporarily for a period of time. That's the difference between a lease and an assignment. I mean, a transfer or a sale. The last one, we have trust. You can also create trust. Trust is one of the ways, one of the instruments, one of the legal instruments you can use to create assets, to develop your estates. You can have, let's say for instance, you have so number of properties in Abuja. You can actually, set up a trust that will manage not just the proceeds, but the transfer of that, what happened to those properties, whether in your lifetime or after your lifetime. We have a lot of net worth individuals who have set up trusts, An exchange, we have another one we call exchange. The exchange is simply swapping of properties. For instance, Pastor Bayo has a land in Asokoro. I have one in Karu. He wants to go into poultry farming. In Asokoro, you can't put a poultry in Asokoro. The stench from the poo of the birds, FCDA may not allow you to site a poultry in Asokoro, depending on which part of Asokoro. But I have a land in Karu that I don't need. So Karu, he can set up his poultry there, so we can do what we call an exchange. And then we execute a deed of exchange, such that we have agreed on the terms. It does not necessarily have to be with money. It can just be swapping. Pastor Bayo, my own land is even bigger than his own, but because of Asokoro, and his own is smaller, I can exchange and we can do a swap. And what we just simply do, we execute a deed of exchange. Now, the second category is transfer upon death. I've told us two categories that you can transfer property. Transfer upon death, that is intestate succession. And if somebody dies without a valid will, it's called, of course, I've mentioned that before. Now, your property can be distributed either according to the law, according to your will, or based on customary law. And then if somebody dies intestate, the family, usually the immediate family, the wife and the children, or where the man has no family, or no children, or the children are not of age, the brothers or the siblings, even the father of a deceased person, where a son dies before his father, the father, if doesn't have a wife, the father is allowed to apply for a letter of administration. So where there's no will, you can apply for a letter of administration to administer. And letter of administration simply is a legal instrument, usually signed by the registrar of probates in the high court, which gives you the legal right, give a named persons who are called administrators, gives them the authority and the legal power to administer the properties of the deceased, right? And usually they'll be governed by principles of fairness, equity, and inclusion. Even though the man has died intestate and left properties, so those immediate families, they will be governed, they will be guided by the principles of fairness, equity, and inclusion in the way they administer it. And the fact that they apply for letter of administration does not automatically entitle them to claim the properties, but it helps them to manage. For instance, if a man dies and he has shares in a company, or a man dies and he has properties, or has a bank account, you cannot access the money unless you get a letter of administration. The man left no will. So one of the things that the bank will ask for is your letter of administration. Now, customary law. Now, I need to make a clarification here. Sometimes there's an intersection or interplay of customary law and the English law. The English law is a will. Anytime you talk about wills and letters of administration, rights, or probates, you are talking about English law, received English law. But when we talk about customs, it's where someone dies and the person maybe the person get married under the Marriage Act. They did a traditional marriage like most of our parents did. Now, if you want to administer their properties, you do it in line with the customs and the tradition of that place. Of course, we also have Islamic law. There are principles, and there are Islamic principles that govern distribution of assets where someone dies under Islamic law if the person is a Muslim. Now let's go to planning for incapacitation. And I want to quickly emphasize this, that when we talk about planning for incapacitation, we are talking about a person what happens where a person becomes unable, that's the word, unable to manage their affairs, either due to illness, maybe temporary illness or permanent illness, mental incapacity. For instance, I know most of us know Olu Jacobs. Olu Jacobs, right? He has a condition now. What's it called? Amnesia. He can't remember things. But the man has acquired properties. So the fact that he has acquired properties and he has a wife, he's still alive, but is incapable. As far as the law is concerned, he's a non gratias. He has lacked the capacity to sign checks or to issue instructions because of that condition. So what happens? The law makes provision for, if he knew that was going to happen eventually, he could have created what we call a power of attorney and give his wife power of attorney to deal with things, to sign checks on his behalf, because he trusts his wife. And they have an instrument to that effect. Because maybe the first time he went to the hospital, they said, we are seeing signs of this. So that's the time we said, you know what, Oga lawyer, come and help me structure something in case I'm unable to remember so I can do this thing. And then there are cases of accidents and old age. So you make arrangement for all of this. Old age. Imagine a time where you get so old that your signature, maybe due to feebleness of age and all that, where you are supposed to sign your signature, you are putting your name, or your signature, your hand becomes shaky, and you are signing. And then when they take the check to the bank, the banks will not honor it because they will say these signatures are not the same. So you can make arrangement for such eventualities that when I grow old, and I become incapable, you should be able to manage my assets in this way. Accidents, eventualities, accidents are things that we don't have control over. Now, these are some of the tools we can use. Power of attorney, you can use power of attorney, you can use trust. Please, let's go to the next slide. Key estate planning instruments. I've actually mentioned some of them. So you can organize your estates through any of these instruments. One, you can do a will, and a will is simply the testamentary disposition of a man or a woman, and I'm very deliberate in saying a man or woman, so that you don't think it's only a man that can do a will. A woman can do a will as well, right? Once you are 18 years, you can do a will. It's just that you are wondering at 18, what does an 18-year-old person has in terms of asset and all of that, but there's nothing illegal about it. If an 18-year or a 20-year-old person has assets, you can do a will. And you can always modify your will through a codicil subsequently. So if you have 3 plots of land or 3 houses, and you do a will in 2020 based on those assets. Now it's 2026, you have acquired more property. You just simply call your lawyer and you amend it, and we call it a codicil, and to be registered and it will be recognized. Now, in doing wills, there are a lot of factors to be considered. There are 3 key parties in a will. The first person is the testator. The testator is the person making the will. And usually when you are making a will, none of your beneficiaries, including your wife and your children, must know. It's a highly confidential process. A third party should not. In fact, if you have in your family an aunt or an uncle who has taken a liking to any of your children, do not involve them in your wills. Because human beings are emotional. Once they leak out an information about your will that, oh, you know what, I'm the lawyer representing your dad, though. You better treat me well, though. I'm the one representing your father. Your father has given, you see that Lamborghini? It's not coming to you. Of course, any lawyer who does that, you lose your license. Lawyers are taught to be confidential. You do not disclose such information. But imagine you have an auntie, and the auntie is so close to you because you take care of the auntie very well. There's a tendency that the auntie wants to be very, she wants to divulge information to you. So if a man involves such an auntie in the making of the will, there's a likelihood that before the man dies, that child will have known about content of the will. So it's important. A will must. That's why when you are doing your will, you must do it in secrecy. Secrecy with your lawyer, only your lawyer. And of course, you need a witness to sign when you have done it. So in a parties to a will, you have, in a will, you have the testator, who is the one giving the instruction. It simply calls the lawyer and give the lawyer instruction, and the lawyer knows how to use technical terms to reduce into writing. Number two, we have what we call the executors. The executors are those that are appointed by the testator and have been saddled with the responsibility to ensure that what the man has written down in his will are carried out to the letter. Executors are not necessarily beneficiaries. Sometimes they don't even get paid. Sometimes they get remunerated. But they are called upon, they are named in the will because they are trusted by the testator to ensure that once they give them the will, everything that's in that will be carried out to the letter. And an executor can go to jail if you tamper with the will or you do otherwise. You can go to jail for it. Then the third person in the will is, or the third category of people are the beneficiaries. Beneficiaries, of course, you understand what that means, that the wife, children, charity homes and all that. Now we have trust. That's another instrument. You can use trust. While a will is ambulatory, from the word ambulance. A will is ambulatory, meaning that a will does not speak until the person who makes has died. A will is ambulatory, it's an ambulance. It's come from the fact that the only time you get to know about a will is when the person has died. While the person is alive, you don't get to hear about a will at all because the will must not speak until the person is alive. If a will speaks while the person is alive, then it's not a will. It's probably a trust or another thing. Then the other one is trust. Trust is the opposite of a will. Trust is done in the lifetime of the person, not when the person dies. Of course, a trust can extend beyond the lifespan of the person who has made it, and the person who makes a trust is called a trustee. All right? And then, of course, the person that are giving instruments, they are called the trustees. And then you make instrument, and then you give them opportunity you give them the powers to manage your properties. Usually, trustees are people that are trustworthy. They have been shown to be trustworthy. They can keep secrets. Gift intervivors. There was a case of a trustee that was named as a trustee in the lifetime of a high net worth individual. I won't mention the name of a high net worth individual. And one of the trustees, unfortunately, got involved with the wife. They started to have amorous relationship. And in the course of one of their rounds of good time, Dr. Theophilus said, there's this hormone you mentioned, that relieves stress, right? So the man, sorry, can I borrow that? What's the word again? What's that hormone? Pardon? Dopamine. Okay, so from the word, is it from the word dope? Very dope, So the man had a lot of dopamine that was released after a very good round of sex. And right there on the bed, the guy started to talk about what the husband has done in the trust. The wife used that information and she used it to her maximum advantage. As a matter of fact, she did things that made sure that the man died faster than he planned to, that God had expected him to die. It was found out, and when investigation was done, it was found out that everything was traceable to the so-called trustee. It was the case of Samson and Delilah. The man let out the secrets on the laps of a woman, and of course, he went to jail. The trustee went to jail straight up. So it's a very serious, serious business. And then when somebody wants to appoint someone as a trustee, I will call them, if I'm the lawyer to the person, I'll call them and said, are you able to hold on to these duties? And I'll bring out these examples that if anything happens to this, you'll be liable, including going to jail. So it's a very serious thing, and I think it's an honor for anybody to want to appoint you as a trustee or as an executor. Why do you want to go contrary? Gift intervivors, that deed of gift, I've mentioned that before. We have a power of attorney that's used for in cases of illness, travel, temporary. Now, a power of attorney can also be used when you are traveling, It's not just about you not being capable. If something requires your continuous presence, your physical presence, and you are going to Canada for 5 years, and as a result of your absence, a lot of things will be, things can go wrong. You can do a power of attorney and appoint somebody who is called your attorney to do exactly what you used to do when you were here, so that the person will be reporting to you. It's simply an agency contract. It's an agency. So you just appoint the person as your agent, and they will do everything you want to. You have supervision on all of that, and things can go and run smoothly, even in your absence. It will just happen be as if you were there. Beneficiary designation, and this happens a lot in the financial sector and in insurance. Beneficiary designation, you have certain financial assets that allows you to name beneficiary directly. For instance, life insurance, pension benefits, accounts. I just assisted one of my clients' wife and the only daughter to get some very good money that was part of the life insurance of the deceased person. In fact, they never knew that they had such a policy in place, or the husband took out such a policy. And the girl was looking, she was a very brilliant girl, she's very brilliant, and the widow was finding it difficult to raise school fees for her. And when I got to know, I looked at the letter of administration. Of course, the man died intestate. He died in an accident, so it was totally unforeseen. So we processed letter of administration for them. After we processed letter of administration, we ensured that we took steps. Of course, there are legal steps to be taken. We took steps, and when we got to find out that the man has taken out a life insurance policy, by the time we look at the policy, it was about 50-something million. That is more than enough to take care of that girl. And because of that money, the girl is in school. In fact, she's in her final year right now. So you can see what these are intentional, deliberate plans. Imagine if such a plan was not in place for her. And the man made sure he mentioned her as direct beneficiary, meaning that there's nobody, the brothers cannot obtain any letter of administration that will supersede that, because he has done what we call beneficiary designation under that instrument, which is totally legal. So the brothers, even though the brothers tried to raise objection, we quieted all of them, because that instrument allows only the daughter to be entitled. And the money, they just invested the money. The money is yielding interest while the girl she's schooling. Now, the widow, she's just looking very healthy. She's not worried. She's not disturbed. When it's time to pay school fees, she just gives instruction to the bank, and school fees is paid. And that's it. So there's a lot of peace and harmony and a lot of peace that can come if you plan your estate very well. Let's go to components of estate planning. I'm winding down. A comprehensive estate plan should include the following. Number one, asset identification. You need to have a clear list of assets. Because, of course, you can't do estate planning if you don't have your assets. You must, first of all, just like doctors will say, you must have a prognosis. What do you have as assets? Do you have land? If you have land, what's the size of the land? Where is it located? You list them. Do you have shares in banks? You list them. Do you have what I call receivables? Maybe you have done contract, or somebody has done contract, and you're expecting to be paid. Maybe you executed a contract for the federal government, and you have not been paid. That's actually an asset. That receivable is an asset. Are you a shareholder in a company and you have a paid-up capital and you're entitled to certain benefits? When dividends are declared, that's an asset. So you do a list. That's the first thing to do. Before you call your lawyer at all, do a list of all of those assets. Then, of course, this will include land, real estate, bank accounts, investments, shares, dividends, and other receivables. Business interest. Now, some of your assets as a person, as an individual, can be intangible. If you have a business interest, for instance, you have some partners in China and you have been discussing with them, and you have just signed a contract with them for you to be a distributor of a particular product. Whatever is due to you in that contract is a receivable. Can also be part of attachment for the purpose of administration. Vehicles, valuable personal property and all that. Your gold, your silver, your trinkets in the house, they are all part of your treasures, part of your assets, and they can also be part of they can make it to your list. I mean, the Fernandez I mentioned, the man has a lot of diamond, runs into millions of dollars. And of course, Daddy, you know the story. Don't let me say too much. Part of the story, a lot of people are just taking it away from another jurisdiction in the, Virgin Island and all of that. Now, liability identification. Now, one of the things that the law does is that where somebody dies intestate or testate, whether you left a will or not,